Our first case will be Homeowners Insurance and Auto Owners Insurance versus Jankowski. The appellant, proceed, please.
I would like to reserve 3 minutes for rebuttal.
So be it.
May it please the Court. My name is Stephen Sinus, the Sinus Tremis Law Firm, and I represent Richard and Janet Jankowski. At first blush, it may seem counterintuitive that the Jankowskis would be entitled to claim Michigan PIP benefits for the severe injuries they sustained while occupying a vehicle they purchased in Florida, used exclusively in Florida, and was not insured under their Michigan no-fault insurance policy issued by auto owners. However, when we look closer at the statute and exactly how the Michigan legislature defined the scope and extent to which Michigan insurance companies are liable for PIP benefits, it makes perfect sense. The legislature chose to create a general rule, that we turn to our own insurance companies even when we're injured in accidents that don't involve our own vehicles. Our insurance companies pay our benefits when we're pedestrians, when we're bicyclists, when we're driving in friends' vehicles, etc. There are some exceptions to this rule, but the point is that the legislature recognized that our insurance companies pay PIP benefits when we're injured in events that have no connection to the vehicles insured under our policy. The legislature also chose to have our rights to claim PIP benefits extend to out-of-state accidents that occur in any state in America, any territory, in American territory, and in Canada, and that right extends regardless of whether we are occupying the vehicles insured under our policy. This is why we're able to claim PIP benefits when we're in rental cars in other states, traveling in friends' vehicles in other states, hit by vehicles in other states while we're pedestrians or bicyclists. So the legislature made it clear. The PIP follows the person. It is not constrained to the vehicle. There's really no dispute in this case about those rights under the No Fault Act. The dispute in this case has to do with whether the Jankowskis are disqualified under Section 3113B of the No Fault Act. Ultimately, that issue turns on whether the Jankowskis were actually required to register their vehicle in Michigan. This is because the language of Section 3113B disqualifies an owner or registrant of a motor vehicle involved in the accident with respect to which the security required by Section 3101 or 3103 if it's a motorcycle was not in effect. Ultimately, we turn to the Michigan Motor Vehicle Code to determine whether or not vehicles are required to be registered in Michigan. In this case, what we have is a vehicle that was never used in Michigan. And so the question becomes, was it actually required to be registered in Michigan? The Court of Appeals answered yes. We submit to the court they erred in that regard. The Court of Appeals reasoning is that Michigan residents, or under the Court of Appeals reasoning, I should say, Michigan residents would be required to register vehicles they use in other states or other countries, for that matter, that bear no relationship to the state of Michigan or never used in the state of Michigan. Ultimately, such an interpretation by the Court of Appeals of the Michigan Motor Vehicle Code to extend to vehicles used outside the state of Michigan violates the Michigan State Constitution's Title Object Clause. In that regard, the Michigan Motor Vehicle Code makes it clear that it is intended to apply to vehicles used in this state, so an interpretation of that code to apply to vehicles outside the state would violate the Title Object Clause. We're ultimately asking the court to issue 2 rulings of law in this case. The first one is that an out-of-state vehicle owned by a Michigan resident never driven in Michigan is not subject to vehicle registration requirements under the Michigan Motor Vehicle Code. And the second rule is that a Michigan resident who is insured with Michigan no fault cannot be disqualified under Section 3113B when injured in an out-of-state accident involving a vehicle the person owns and registers in another state and never operates in Michigan.
Mr. Sinus, what if we agree with you that your client's car was properly registered in Florida, so there was no requirement that it be registered in Michigan? Couldn't you still read 3113B to say that the car, because the car was not registered in Michigan, it's not a car for which, if there's an accident involving it, they can claim their PIP benefits? Isn't there, just even putting aside the registration requirement, this is a car that's excluded under 3113B, which seems to conflict, I agree, with 3111. How would I resolve that conflict?
Well, Your Honor, the way I would submit to the court that can be resolved is simply that 3113B turns on 3101. And 3101 says the owner or registrant of a motor vehicle required to be registered in this state shall maintain PIP benefits or PIP no-fault coverage. So the issue is, in order to have 3113B disqualification, you have to show that the vehicle was actually required to be registered in this state, or you have no disqualification. So that's how I would submit to the court you reconcile those issues.
But doesn't 3113B only invoke the security required by Section 3101. I understand your argument that the security required by 3101 is arguably only required under certain circumstances and conditions, but nonetheless 3113 only focuses upon the security required by Section 3101, and that security seems to be a certain kind of personal injury protection security.
Your Honor, our position on that issue is that the plain language of 3113B turns on whether the vehicle involved in the accident was not insured with no-fault insurance coverage. And the exact language says that the vehicle involved in the accident with respect to which the security required by Section 3101 or 3103.
Which focuses on the vehicle, not the person, right?
It focuses on whether the vehicle was actually required to have PIP. And that turns back to the issue of whether it was required to be registered. That's what triggers the obligation for a vehicle to have PIP coverage.
That takes us to MCL 257.216, doesn't it?
That does, yes, Your Honor.
Every motor vehicle, recreational vehicle, trailer, semi-trailer, and pole trailer when driven or moved on a street or highway is subject to registration and certificate of title provisions of this Act. And it was driven on a street or a highway, so why isn't it subject to the registration provisions of this Act, that being the Michigan Act?
That gets back to our argument regarding the title object clause. The Michigan Motor Vehicle Code makes it very clear in the preamble that it's only intended to regulate vehicles operated in this state.
How often do we use the preamble to interpret a statute?
It's not the use of the preamble itself. It's that the preamble explains the purpose in the situation, and there have been a number of cases where the court has recognized the purpose of a statute is set forth in the preamble, and that guides the analysis of whether there's a title object problem. And so in this case, the preamble of the Motor Vehicle Code makes it very clear that in enacting the code, the Michigan legislature was intended only to regulate vehicles used in Michigan. And so the argument would be, ultimately, that with that being the case, the registration requirements set forth in MCL 257.216 cannot be interpreted to apply to vehicles outside the state of Michigan. And I'll take the opportunity to paint the picture of a Michigan resident who owns a vehicle in any other state, never operates in Michigan. The Motor Vehicle Code also says that those who fail to register vehicles pursuant to the code are guilty of a misdemeanor. So if a Michigan resident owns a vehicle out in California, never uses it in Michigan, the interpretation of the Court of Appeals about the registration requirements would mean that that person is committing a misdemeanor if they don't register that vehicle that they only use in California here in Michigan. So that's another reason to look at the practical reality in addition to the title object argument that we do not want to place Michigan residents who own vehicles outside the state of Michigan to have to register them here, and if they don't, they'd be subject to a misdemeanor.
It seems to me that the appellees in this case understand the relationship between 3113 and 3101 in much the same way that you do. It doesn't seem like there's any fundamental disagreement in terms of how those two provisions are connected. I guess I would just ask you at some point to consider the language of 3102.2, which refers to a vehicle that does not have security in effect and that is required to have security. And it talks about several things that seem to be missing from 3101. First of all, it refers to a vehicle with respect to which security is required, and then it refers to that vehicle not having in full force and effect security complying with this section. The reason I suggest 3102 for your consideration is that it seems to adopt the basic understanding of 3101 that you've suggested, even though it has far more specificity in connecting the lack of security in the vehicle than does 3101. 3102 is much more explicit in having established the kind of relationship with 3113 that you're arguing. Could I ask you to comment upon the greater specificity in 3102 and why it doesn't create some negative implications for what 3101 means?
Yes, indeed. With respect to 3113, I need to point out, and obviously the court's aware of this, but the plain language doesn't refer to 3102. It says 3101. So to a certain extent, when interpreting a 3113B issue, what 3102 says is really not the issue, is what 3101 says. I acknowledge that 3102 does have more specificity, as you point out, Your Honor, than 3101. But I don't believe that 3102 suggests that 3101 should be interpreted in a different way than what we're submitting to the court today. It's 3101 turns on whether the vehicle was required to be registered, and that is the issue. So 3102 is more specific, but yet it does not undermine the fundamental principle that a vehicle that's not required to be registered is not required to have no-fault insurance.
I guess it seems to me the question in 3113, again, you and the appellees seem to agree on this, and I respect that fact, but the issue in 3113 seems to be, in connecting it to 3101, whether 3113 is referring only to the particular type of security that's required, or whether it also implicates the circumstances in which that particular security is required. I'm suggesting that the reason to look at 3102 is that if 3102's language had been replicated in 3101, your argument would be given much greater force than it is without the language in 3102 having been incorporated in 3101. 3102 really does tie together the circumstances of the vehicle in the lack of a particular kind of security, whereas 3101 is much more ambiguous in that respect.
I guess looking closer at the language of 3102 and subsection 2 is what you're referring to. Is that correct, Your Honor?
Yeah, that's not a random bit of law. 3102 comes after 3101, right?
Yes, it does. But 3102 does also focus on non-resident owners, and we have a Michigan resident.
It has a different subject matter, but it also refers much more clearly and explicitly to the relationship between the security and the absence of the security on the part of the vehicle owner.
In looking at the language of 3102.2, not to reiterate it, but just to make sure we understand the analysis here. An owner or registrant of a motor vehicle or motorcycle with respect to which the security required, who operates the motor vehicle or motorcycle or permits it to be operated upon a public highway in this state without having in full force and effect security complying with the sections or section 3101 or 3103 is guilty of a misdemeanor. I would submit to the court that that is just another way of saying what 3113B says, which is that if you operate a vehicle on Michigan roads and it's required to be registered, you're guilty of a misdemeanor. 3113B says that if you operate a vehicle that's required to be registered and you don't have PIP, you're disqualified from PIP. I would say that essentially the two statutes, or the two sections, 3102 and 3113, are expressing the same concept.
Thank you.
Thank you.
Are there any further questions? Okay, thank you, Mr. Sinus.
Thank you.
Ms. Hillock?
Good morning, Your Honors. May it please the Court. Kimberly Hillock on behalf of homeowners and auto owners in this case. I think the important jurisprudential significant question is whether the legislature ever intended people to claim benefits from no fault without paying into the no-fault system in the way designated, which is on a per-owned vehicle basis. Now, it's sometimes said that no-fault insures the person and not the vehicle. But the basic fact is that the way you get the system pays claims with money, and the way you get the money is to assess premiums on a per-vehicle basis. Now, this per-vehicle basis is reflected in the MCCA assessment, which, and this court has twice indicated that if an insurance company fails to pay the MCCA assessment for a vehicle that is located outside of Michigan, that the insurance company cannot get reimbursed from the MCCA. The per-vehicle assessment is also reflected in the penalty provision under 3113B, which precludes coverage for the owner of a vehicle with respect to which the security required by 3101 was not in effect. Now, that says that the security required, and 3113B also does not mention whether the vehicle needs to be registered, like the registration, the reference to registration in 3113C. And the focus of 3113B is simply on what security is required under 3101 sub 1, not on how it is required or when it is required. When the security required by 3101 sub 1, and the security required by 3101 sub 1 is personal protection insurance, property protection insurance, and liability insurance. And to address what Chief Justice Markman said, it was not the insurance companies who made the argument regarding registration. The insurance company's position originally was that under 3113B and the exclusion in the policy that there was no coverage for this accident because they had not obtained Michigan PIP. It was the Jankowskis who introduced the whole registration requirement into the equation, and the insurers responded with the published case of Wilson versus League General, which stated that registration was required under 257.216. And as Justice Zara recognized, 257.216 is broadly written to require Michigan registration of all vehicles driven on all roads unless accepted, and there is no exception that applies in this particular situation. Now, the language in 500.3111 is reflective of the same language that is in 3114.
Counsel, good morning. Just a question for you.
Yes, Your Honor.
Under the argument that it goes with the car and not with the person, how does the insurance company assess risk?
The payments are made based on the car. That's how the money is paid into the system. That was my point on that. The risk is, of course, based on what the drivers are involved, their records, and the named insureds.
But what are you insuring, the car or the person?
I think the No Fault Act considers both, because you've got the MCCA requirement, assessment requirement, and you've got 3113B, which specifically excludes coverage if the vehicle is uninsured and owned by, if the person is injured in a vehicle he or she owns and that vehicle does not have coverage. So it considers both. And so under 3111 has the same language as 3114 sub 1 and sub 4. It talks about the named insured or the person named in the policy, the spouse, and the any relative domiciled, as well as any occupant of the vehicle. And in Belcher versus Aetna Casualty Insurance and Surety Company, this court noted that 3114 was an entitlement provision because it and 3115.
So, counsel, I have a question. So, just following up on these points, in this situation, the plaintiff's lease, it was a long-term lease, correct, of the vehicle in question. The Lexus was a long-term lease, right?
It was a one-payment lease, yes.
Okay, but it was a lease. They didn't own the vehicle. They were leasing the vehicle, right?
A lease was signed, correct.
Okay.
I mean, under Michigan law, they would still be an owner because they were the ones with the exclusive use of the vehicle.
Okay, so taking that concept, let me change the facts up a little bit and see kind of what your perspective would be. Instead of them leasing the vehicle the way that they had leased it, what if they just did a long-term lease with Avis or National and did it through National or Avis? Would that change this in any way?
I'm not sure if that would change it or not. I mean, you have...
Well, if I go to Florida and I rent a vehicle, would that change it? If I'm using Budget or National, if I'm doing a business trip and I rent a car in Florida, does that change the dynamic? Instead of it being a long-term lease with the way that they did it, if you go through a rental agency, do Michigan residents have to now be concerned if, under your argument of this, if they're traveling out of state or going to Florida and they go through Budget rental car? Is that something I should be worried about?
I think in fact, it might be called it's Enterprise Rental Company or whatever. I can't remember the name of the case. I'd be happy to submit a supplemental brief on it. But there are cases that say that the rental car company is required to provide the insurance and that the rental company cannot put that burden on the driver's.
But the question is, if they're providing, right, and I guess my question is, if they're, let's say they're providing Florida insurance, the rental agency isn't going to be providing Michigan insurance, they're going to be providing Florida insurance. So does that have an impact on this? If I'm renting a car in Orlando, I'm not going to expect that Enterprise is going to be insuring it under a Michigan provider. They're going to be using a Florida provider. So is that going to change how this is going to equate?
I really don't think so, Your Honor, because 3113B specifically refers to the owner of the vehicle whose owned vehicle is uninsured. So I don't believe that will affect it, no.
Okay.
Counsel?
Yes, Your Honor.
When I was likening your argument to those of the appellant, what I was referring to specifically was what I understand to be your argument that 3113B disqualifies a person from PIP benefits if he or she was the owner or registrant of a vehicle with respect to which a no-fault policy, i.e. security, was not in effect but should have been in effect. I don't read 3113 that way. Instead, I see that as simply pertaining to those cases in which the injured person was an owner or registrant and the vehicle was not covered by a no-fault policy, period. So that's where I disagree with your argument. I also disagree with your absence of an argument. To the extent that defendants prevail in this case, I wonder whether or not that doesn't call into question what I've always thought was a very traditional, maybe even a first precept of insurance law, that an insurer can't be held liable for a risk that it did not agree to assume. And that would be the case here if any decision was to be announced in favor of the defendant, right?
Absolutely, Your Honor.
Yet that was never argued by yourself, as to the best of my knowledge. Why was that the case?
It had to have been an oversight. I've made that argument many times in many cases. I mean, it's the Hennesser case that says that an insurance company can't be held liable for a risk it did not assume.
But how is this a risk that you didn't assume if your argument is that it goes to the car and not to the person?
Because the car was not insured under homeowners policy. It was insured under an Allstate policy issued in Florida.
How is it a risk you didn't assume just given the plain text of 3111, though? I mean, the plain text of 3111 says that the person whose injury is the basis of the claim was at the time of the accident a named insured under a personal protection injury policy. There's nobody disputes that the defendants were such people. So why doesn't 3111 mean you did assume that risk?
That's a very good question. And this goes back to my argument that 3111 has the very same or almost identical language as 3114. And this court has on numerous occasions applied 3113B to 3114 arguments. And so going back to the Belcher opinion, which said that 3114 was an entitlement provision because it and 3115 were the only sections where the persons are given the right to claim personal protection insurance benefits from a specific insurer. And so 3114 sub 1 states that a personal protection insurance policy described in 3101. So again, there's no reference to the registration requirement. It's just talking about the policy described, and that is what applies to somebody who is injured in or to a.
But I think I agree with you that if there was some clear way to understand 3113B to somehow override 3111's plain text, then that would be an easier case. I don't see. Can you point me to anything in the statute that would allow me to make that jump. I mean, I don't know how I get to say that 3111 is overridden somehow by 3113B.
I can only go back to provisions or the law pertaining to contracts, which I know don't necessarily apply to statutes, but you've got to read them all together. You've got to read all the statutes together. And when you've got a vehicle-specific exclusion, that has to be applied, and it's a specific exclusion which would apply over the general provision. So the general provision is that the person has coverage, but the vehicle-specific exclusion would then take priority.
Isn't a possible answer to Justice McCormick's very thoughtful and legitimate question that somehow there has to be a correlation between the personal protection insurance and the car and the vehicle?
Absolutely, Your Honor.
How would you explain taxis?
Well, taxis are covered under, what is it, 3114?
But you still run into the issue, it's a Florida policy, right?
I'm
I'm
sorry?
riding in a taxi in Miami, I'm going to be covered under a Florida. How is it different? Because doesn't it go back to the issue of whether it goes to the person or the vehicle? You're indicating both, but where do I put the emphasis, the person or the vehicle?
I think, all right, so the taxi situation, you have a no-fault policy that covers you. That's the general rule. 3113B would not come into effect because the taxi is not a vehicle you own. So therefore, the general rule would still apply and you'd be covered. It's only when you're in a vehicle that you own that is uninsured by PIP that you do not have PIP coverage.
Okay.
Any further questions?
Not for me.
Thank you very much.
Thank you, Your Honor.
Ella, you have 3 minutes to go, Mr. Asinas.
I'd like to make my remarks focused on the court's astute questions regarding both the insurance premium issue and the tension between 3111 and 3113. As the court recognizes, there is this right under 3111 for people who have no-fault coverage to be covered and if they're in an accident, regardless of whether they're occupying the vehicle insured, and an accident out of state for that matter. So this is a right under 3111. Their interpretation is that for this subset of people, such as the Jankowskis who own a vehicle in another state, they're somehow deprived of their 3111 rights. And so there's this tension between 3111 and 3113, and to the extent that there's any ambiguity in 3113 along the lines that Justice Markman has suggested, we would submit that there really is not any ambiguity, but if there is determined to be 3111 rights are clear and that the Jankowskis representing this subset of people should not be disqualified under 3113B. With regard to Justice Markman's concerns over insurance premiums, I want to first point out, as the other justices have also indicated, that no-fault insurance coverage is being sold with the idea that it follows the person and that it's going to cover us when we're in out-of-state accidents not occupying our vehicle. So there's already a risk assessment being imposed on our premiums by our no-fault insurers for these out-of-state accidents. I would suggest to the court that the extra risk of a person owning a vehicle outside the state of Michigan and having to pay PIP benefits for that person when injured in that vehicle is not significantly greater than the premiums already factored into our no-fault insurance premiums. And to the extent it is greater, there is nothing in the law that would prevent an insurance company from asking somebody who's applying for insurance whether they own vehicles outside the state of Michigan. And if the answer is yes, and it's several vehicles, then premiums can be adjusted accordingly. There's no reason why that can't be part of the rate-making procedures by insurance companies. So with that in mind, there is already recognition that 3111 covers out-of-state accidents. That's built into our premiums, and they can also ask these questions to make sure that they're covering the risk for any vehicles the people own. I'll also point out that the law has been made very clear in this state that when people somehow file an application for insurance that contains misrepresentations or other fraudulent statements, the coverage goes away. So if the person somehow lied about having vehicles outside the state, they would also be subject to voiding the policy in that event.
Is there really a tension between 3113B and 3111?
I don't think there is, actually. When I say tension, I was saying that those who were interpreting 3113B along the lines as suggested by Applee, there really isn't if you look at 3113B along the lines that we've suggested.
3113B simply says that you're not entitled to the PIP benefits if the motor vehicle involved in the accident is one in which security was required. That's the question. If security was required, 3111 doesn't come into play. If security wasn't required and you're outside of the state, then you get benefits. I mean, I don't see the tension here.
I agree, Your Honor. If the question is whether it was required, and if the vehicle is not registered or required to be registered in this state, the insurance isn't required. So there is no tension in that regard.
Thank you, counsel.
Thank you.
Case will be submitted.